Hi, I'm Tom Vanderbloemen. I'm a lawyer in South Carolina. I practice in the area of trademarks, franchises, and other related areas of the law. We send out a regular newsletter. You can see the link in the description below, with random news about trademarks, franchises, and other legal stuff, as we call it. Most people probably like it for the trivia questions we have and our regular dog pictures, but the news is also kind of interesting. This is a recap of our January 23 newsletter, where we discussed winter storm trademarks, Patagonia the clothing brand versus Patagonia the drag queen, South Carolina's new online trademark filing system, and a frequently asked question about the differences between the U.S. Patent and Trademark Office and your Secretary of State's office, and what they each do and what they don't do when it comes to trademarks and business names. If you like this kind of stuff, you can like this video and subscribe to our channel. You can also sign up for the newsletter in the description below and see a link to last week's issue. When we wrote the newsletter, everyone was getting ready for the winter storm that was coming to our area. They're buying milk and eggs and bread and all the kind of things you do when you get ready for the storm. Now, we did get quite a bit of a wintry mix, and you can see that I'm in sort of my snow day sweater as opposed to wearing my coat and tie. And our law clerk certainly likes it. We're hoping the power stays on, but it all made us think about winter weather trademarks related to winter weather. As it turns out, there are several trademark registrations for the term snow day. We found registered versions of this mark for a variety of products, some that are like a snow day and some that aren't really. There are teas and cocoa and candles, registration for Snow Day for those products, owned by David's Tea in Canada. It also sells a Snowball Fight tea. We saw a registration for Snow Day for fleece jackets, owned by a Chinese company. We also saw a Snow Day registration for video games, slot machines, and bingo machines, which is owned by King Show Games. And then we found a Snow Day registration for live plants, which was owned by a Michigan nursery. We also saw a registration for Schneetag, hope we're saying that the right way, Schneetag, which apparently means snow day in German. It's owned by Aspen Skiing Company and refers to the closing day festival at Snowmass. You've probably seen videos like this, but essentially people build and send crafts down the slopes in teams of 4 and then try to float them across a pond. The Snowmass site says it translates to daredevils willing to propel themselves down a hill, over a jump, and across a pond on a craft they built themselves. There are also many snow-themed beer trademarks, which I guess is not all that surprising, including Snow Day and another mark, Accumulation, both owned by New Belgium, those are the people who brought you Fat Tire, and Snowed In, which is owned by Sierra Nevada. Another company tried to register the mark Wintry Mix, but it was blocked based on someone else's registration for Wintry Fix. And remember, that's a good reminder that marks don't have to be identical to create a conflict or potential confusion. We were a little puzzled by one beer trademark we saw, Yellow Snow, owned by Oregon Brewing Company. That's the same group that brought you the Rogue brand of beers like Rogue Dead Guy. The company declared bankruptcy just a couple of months ago, so you might want to watch whose Yellow Snow you're drinking this year. Of course, you should probably watch that any year. One article we read about the bankruptcy said that the beer company was in liquidation, but we can do better than those kind of jokes. As winter comes around, loyal readers of our newsletter will recall that we do have a certain fondness for clever snowplow names. Even if they may not be trademarks, they could be, because after all, trademarks are often about combining clever terms into a suggestive trademark, as we sometimes say. Some cities even have websites and contests about the names of snowplows. Manhattan, Kansas has a website with snowplow names like Better Call Salt, one of our favorite shows, at least a reference to it, Control Salt Delete, the Snowtorious B.I.G., and in a name that must have been submitted by a middle school, I've plowed 6 or 7 streets already. The Minnesota Department of Transportation has an annual snowplow naming contest with winning names like I Came, I Thaw, I Conquered, Taylor Drift, Clark W. Blizzwald, You're a Blizzard, Harry, Cleopatra, and Scoop, There It Is. We hope those in the path of the storm fare well, keep your power and heat on, and stay safe. In the meantime, we also hope you enjoy winter weather trademarks. Patagonia versus Patagonia. You probably know Patagonia, the apparel company and the outdoors company. You may not be as familiar with Patagonia, a drag queen with a concert tour and 1.5 million followers on Instagram. The two are certainly familiar with each other, as shown by a trademark infringement lawsuit Patagonia filed this week against Patagonia. Patagonia has known about Patagonia for a while. The lawsuit says that in 2022, when Patagonia was exploring a possible collaboration with Hydro Flask and the North Face, Patagonia discussed with Patagonia concerns over improper use of the company's brand. Patagonia said it explained that it had a need to protect the Patagonia trademarks, but also leave some space for Patagonia's fundraising in support of environmental causes. This happens sometimes in trademark law. People using similar terms, maybe even one person using a term inspired by someone else's trademark, rather than shutting down the use, they may actually agree that the use can be permitted as long as that person stays in their lane, so to speak, and doesn't cause confusion in the marketplace. It's not really a license agreement. It's sometimes called a coexistence agreement, where a trademark owner says it won't object to the other person's use as long as certain conditions are followed. Here, it doesn't look like a formal written coexistence agreement was signed. Rather, Patagonia is relying on emails to show that the understanding was reached with Patagonia about what would and wouldn't be done with the trademark. For example, Patagonia believes that Patagonia would not use that term on merchandise or use Patagonia's trademarks. Patagonia now believes Patagonia is violating the understanding they reached. The concerns probably weren't helped by the fact that Patagonia filed a trademark application for Patagonia just a few months ago. Now, maybe because it's worried about negative publicity from the lawsuit, Patagonia is only seeking $1 in damages, with its primary goal being to stop what it believes is the infringing conduct. Maybe it's getting closer to what it wants. The Patagonia merchandise website currently says it is sold out. It's not the first time that Patagonia has acted to protect its brand. The lawsuit referred to prior cases against Fratagonia, Catagonia, and Patagonia. And in full disclosure, I've been known to wear a Patagonia jacket while walking our law clerk. South Carolina now has an online trademark filing system. We're pretty excited about this because previously you had to mail in paper documents that people actually signed, as well as send in paper checks for the filing fees. I mean, who uses checks? Even the search system is now being updated. It's a nice change from the prior process for how we used to do searches. In the past, we used to download a PDF, and by past I mean just a few weeks ago. We would download a PDF of all the registered trademarks in South Carolina and then scroll through them, seriously, to see if there were any close or conflicting trademarks. Not necessarily the most precise system. So now we can use the electronic system as it rolls out. You can even use this new system to register a state-level livestock brand, though I admit this would be something new for us if we've never had to do that before. There are likely still a few kinks to work out in South Carolina's new online system, including how to prepare applications and for other people to sign. That's something you can do with the federal system at the U.S. Patent and Trademark Office. But still, this development in South Carolina is an encouraging one. And why register at the state anyway? Most trademark applicants prefer to apply at the federal level at the U.S. Patent and Trademark Office, but sometimes that's not an option. The state trademark registration system can also be faster and less expensive and sufficient for what a client needs at that time. It's part of an overall strategy, and now just a little bit easier to manage at the state level. What does a Secretary of State's office do compared to what the U.S. Patent and Trademark Office does when it comes to business names and trademarks? Who does what? This is a question that trips up many people, including many lawyers. Most states have a Secretary of State, and that's where you form a new business, like an LLC or a corporation. That's how it is in South Carolina. One of the first questions you have when you're forming a company is, what will the name of the company be? As far as the South Carolina Secretary of State is concerned, and most other Secretaries of State, you can't have two companies with the same business name. And so if the name is unavailable when you're forming the company, it just means you have to form it under another name. But whether a business name is available or unavailable when you're forming the company at the Secretary of State's office is not really the same thing as whether you can use a name with the public as a trademark, for example. In fact, the Secretary of State's offices may accept names that are very close to each other when you're forming a company. Vanderbloemen Industries 1 LLC might be able to form, as well as Vanderbloemen Industries 2 LLC. Even if the businesses are very similar And that's just because the system doesn't really care what kinds of goods or services each business might be offering or selling, or how the names would actually be used. It's just simply to form the business at the Secretary of State's office. That issue, though, the issue of whether there's potential confusion between the names, that's something where trademark law comes in. Trademarks are created by using names as a brand or using names in your business, even if they are not registered with a government office. Let's repeat that. A trademark can exist even if you don't register it with a government office. Now, many companies do register their trademarks, and there's several benefits to trademark registration. Trademark registration can occur at the federal level, at the U.S. Patent and Trademark Office, and also at the state level. It's tricky, though, because sometimes the state-level trademark registration is handled by the Secretary of State, which is the same agency that handles business filings. Usually it's in two different divisions, one for business filings and one for state-level trademark registrations. So the short answer is, the Secretary of State often handles business filings, business formations, and state-level trademarks, while the U.S. Patent and Trademark handles federal-level trademarks. If you like this kind of stuff or just want to see our dog pictures and trivia questions, sign up for our newsletter in the link in the description, and like and subscribe to this channel.